Good afternoon, everyone. Welcome. My name is Caitlin Morgan, and I am a staff attorney with the Unemployment Law Project. The Unemployment Law Project is the only freestanding legal aid organization in the United States that is devoted solely to unemployment issues. We have been here since 1984. We provide free legal representation and free advice and counsel to people in Washington state who have been denied unemployment benefits or whose award of benefits is being challenged. We are here today with our weekly webinar, which occurs every Monday at noon. We are glad you've joined us today. The purpose of today's webinar is to share the latest news on unemployment benefits, to provide updates on a lawsuit that is currently going on regarding unemployment issues, and to answer your questions. We will share commonly asked questions during the presentation, and I will be monitoring the Q&A chat box to address your questions live today. I'd like to introduce today's speakers from the Unemployment Law Project. Joining us today, we have Executive Director John Turpak and Policy Director Ann Paxton. I will now turn it over to John to get us started. Thanks.
Good afternoon. Before we hear from Ann, I would like to just note a couple things. Last summer, the Sheridan Law Firm filed a petition for writ of mandamus in this Supreme Court, asking the court to order the Employment Security Department to make prompt payments for benefits. And the court looked at it for a while, and then in the fall remanded it to Thurston County Superior Court. So the writ is in Thurston County Superior Court. In the coming months, there'll be a briefing on the issue, and there will be a ruling, I assume, later in the year. So there are no updates now, but I just want people to know that it is active and ongoing. And also,
John, we can't hear you.
Okay, let me, how about now?
Yeah, there you go.
Okay, so I want people to know that the case is ongoing. We were disappointed it was sent down and that the Supreme Court could not rule on it right away, but the case is active and moving ahead, and we will update you in coming weeks on any progress or updates. Also, in Congress, the U.S. Congress will be voting on a stimulus package. Of course, you've probably seen this on the news. We're not, so I would urge people to follow that closely. And when whatever is passed and signed by the president, we will give updates on what it means to claimants in Washington state, especially on the issue of additional weekly payments added onto a regular unemployment claim. Thank you.
Thank you, John. Thank you for tuning into our webinar. We, as you know, we do this every Monday, except for last Monday. So we've got 2 weeks of backlogged news to catch up on. And there's never kind of a dull moment in the unemployment world. Wanted to start by just mentioning the continuing implementation of the Continued Assistance Act, which has extended a lot of the benefits that from this was the one signed in December, a lot of the benefits that were signed under the CARES Act. The benefit now for PEUC is 24 weeks. That's up from 13 weeks. And the $300 available every week as an extension is continuing. And the unusual thing about this set of provisions extending the CARES Act is that is the mixed earner unemployment compensation and the EUC, which helps this population of people who are both self-employed and have a regular employment with an employer. They get an extra $100 under certain circumstances. If they have at least $5,000 in self-employment income, they can get an extra $100 on top of the $300. So, and I will mention a little bit more about the stimulus bill that is now pending in a few minutes. I wanted to, this is a program progression chart, which is very helpful. And I've left the link here for reaching this because it's a good summation of what the provisions are under this continuation of the CARES Act. It was really important to me that we talk a little bit about identity theft because everyone probably knows that the auditor has been conducting several audits of the Employment Security Department. And many of them have been very critical and many forthcoming will be very critical. But unfortunately, the data that the Employment Security Department sent to the auditor was exposed in a very big data breach. And this occurred about the same time that we're finding enormous fraud coming up in California. When Washington's fraud was around 600 million, they think they clawed back 300 million of that. So $300 million. In California, they're looking at something more on the order of 10.5 billion to 12 billion. And one of the really alarming things that I recently saw about this was a story about a Sacramento couple who, between the two of them, had cashed in on $550,000 in people's unemployment funds. Well, where did they get how did they manage this? Well, they had access to something like 55 profiles with names, dates of birth, social security numbers, usernames, and passwords associated with the unemployment accounts. That has a strange similarity to the data that was breached in Washington State in last month. So that's data that may not be used this week. It may not be used next month. People may sit on it. The criminals may sit on it for a year or two. And that's what they did in this Nigerian scattered canary original fraud that occurred in April. Very effective because people tend to drop their guard and may not realize that their data has been exposed. And they may not really understand that it can be, there are ways to stop identity theft if at all possible. So these are just some things that we've found from the financial institutions are being recommended. Change your passwords, set up a two-factor authentication on all your accounts. For example, you can have a special code word. Then to activate your bank and credit card account alerts, there are different ways to do that. And also to monitor your accounts for unusual activity. Consider placing a fraud alert or a freeze on your credit report. And you can do that by contacting the 3 credit companies, which are Equifax, Experian, and TransUnion. And then watch out for unusual emails where there might be people probing you for different information, text messages or phone calls. And you can get a free credit report at the FTC. If you go to ftc.gov, you can find more tips like these, very helpful and extensive advice on security. And you can find out how to check your credit report. And also, one additional interesting piece of advice is to get a jump on your taxes early to prevent a scammer from using your social security number to file a fraudulent return. So if you file your return before the fake return, that's going to raise a red flag that will be in your favor and not the criminals. Another piece of very interesting news this week is that the Office of Administrative Hearings has announced that they're seeking extra funding for the 2021 to 2023 biennium. So this is they're asking for $22.3 million, and this is because of the backlog in their caseload. We knew last year that it was very alarming that so many appeals have been languishing at the Employment Security Department instead of being sent to Office of Administrative Hearings for a hearing to be scheduled. So that has slowly worked out, but in the meantime, there's been an increasing backlog behind it that has not been able to be addressed. So this is an excerpt from an appeal that the chief judge at the Office of Administrative Hearings just sent to the House Appropriations Committee in the state legislature, explaining why they need $22.3 million more, because in the past, as long as ULP has been around, the typical resolution time for an appeal, after an appeal was filed, was about 30 days. Now it's already gone up to several months. But shockingly, a backlog that they have a backlog right now of 31,000 appeals, but they're not really making any headway because the backlog keeps getting larger and larger. So the wait time now is 4 months, and without additional resources, they're saying their backlog will rise to a wait time of 23 months. So a 2-year wait time to have your appeal resolved is a pretty serious negative black mark against the whole appeals process, because a lot of people are going to drop out of it at that point. And then basically they've been deprived of any chance to appeal a negative ruling. So for ULP, the big news is we have been working on very hard on several bills, but the main ones we've contributed the most time to are these unemployment benefits reform bills, SB 5193, which would make several improvements to the claims processing at ESD, and SB 5064, which would change the laws regulating voluntary quits to add a provision so that when people have some changes in their work hours that cause them to find that their child care or vulnerable adult care that they need to deliver is inaccessible, that gives them good cause to quit their job and to look for another job. So this is a bill we've been working on for several years now, and we're hopeful this year that there is key support for it. It's actually gotten through both of these bills. The claims processing bill and the caregiver bill have gotten through the key committees, labor committees in the House and in the Senate. So those are significant votes. They're now in the Rules Committee, heading for probably not going to have to go to appropriations. I can't be sure of that yet, but I think that they may pass. They may be able to bypass that in this legislative session. But the vote could come up on the floor anytime at this point. So we'll keep you posted. Right now, the Senate bill is finalized. The House bill is still being worked out, the final form of it. But at this point, tomorrow we're going to be asking supporters of ULP to send out this is an action alert to contact your legislators. You can look them up on this legislative tracker. And I think we have, if you have that link, Aaron, for the legislative tracker, it's on here as well, app.leg.wa.gov, that you can look up your senator's contact information, and we have a draft. We have a draft that you can use here as suggested wording to ask your senators to support 5193. What 5193 does, first, is establishes a reserve force of adjudicators. As everyone knows, that finding an adjudicator, first getting through on the phone, but then when you do, finding an adjudicator who can help fix your case has been a real challenge over the last year. So this would also set up accountable systems for fast and reliable benefits, including a requirement that communications with claimants, those are notices and letters, that they have been tested on claimants for understandability. So interesting that this is kind of a novel idea, but everyone knows that there has been a lot of confusion stemming from contradictory notices, unclear notices, and so on. Also, it sets up open data reflecting the Employment Security Department's performance. And then, as I mentioned, SB 5064 protects the benefits of family caregivers who have reasonable restrictions on their hours of availability so that they can quit their job if they need to and seek other work. This is not a leave program. It's very important to stress this because there is a paid family medical leave program, but that is for people who can afford to not work. There are many family caregivers really want to work and have to work. So we think these are very strong bills that have really good potential this year. The American Rescue Plan that John was mentioning. So sorry, it looks like I'm going to have the blower working while I'm talking, but I'm trying to get through this quickly so I can mute myself. So the American Rescue Plan of 2021, this would be the stimulus bill. It has been it's been under a lot of debate in Congress, and the House is talking about passing a bill that would extend the current benefits of $300 a week, raise it to $400 a week, but extend it to August 29th. And that's a week shorter than President Biden's proposal, which would have gone to September. The reason for that is they had inserted a program to fund multi-state, multi-employer pensions. It's not really related to a lot of the other issues in the stimulus, but right now it's in the current pending bill. So we'll see if that remains there. That cost some of the unemployment benefits that was taken out of that funding. But this rescue plan stimulus would set the duration of pandemic unemployment assistance, PUA, up to 74 weeks. So raising it from 50 weeks. It's interesting that a large percentage of people have been long-term unemployed, longer than 27 weeks, which is very unusual, only occurs in a sort of an extended emergency condition, such as the one we're in right now. And the program would also extend PEUC program, that's the extension onto regular benefits, to 48 weeks. That is up from 24 weeks. So they're saying that this is they expect it to be passed and signed by mid-March. They're going through, in order to need a smaller majority to pass the bill, they're going through the budget reconciliation process. Finally, I wanted to bring up our TikTok star at ULP. This is Lavina Staten, who has done several TikToks that are public service announcements on behalf of really something that the Employment Security Department should be doing. But this, I'm sure they wouldn't do as good a job as Lavina has done. And these have been extraordinarily popular. We're so thrilled that a lot of these explanations, they've been so clear that people are learning the basics of unemployment law. They're learning about glitches, and they're figuring out a lot of things that have been difficult. I'm going to stop sharing for 1 second so I can switch to an online video here. So I wanted to play first Lavina's, let's go back to, no, I lost my share rate. Okay. This is a video that arose because we've noticed a lot of people in our, among our claimants, the clients that we've worked with, have lost their hearings and lost their appeals because they quit a job because of worker safety issues, which is very common with the COVID risks that are out there, but they didn't talk to their employer first. And a lot of people don't realize that this is necessary, and but the judges certainly know. So I wanted to play this quickly. This is Lavina's explanation of how this works.
Can you get unemployment in Washington state if you quit your job because your job was unsafe? Yes, but only if you report the safety problem to your employer and they fail to fix it in a reasonable period of time. To receive unemployment benefits after quitting your job, you have to have good cause in the eyes of the law. Good cause means the law considers your reason for quitting to be valid. In Washington state, if your worksite safety deteriorates, you report the issue to your employer, and your employer fails to fix the issue in a reasonable period of time, you can quit your job and still qualify for unemployment benefits. 2 notes. 1. The safety issue cannot be an accepted risk in your field of work. For example, a skyscraper window cleaner wouldn't qualify for unemployment if they quit because it's dangerous to be so high up. However, if the window cleaner's employer did not provide a harness and rope to catch them if they fall, that window cleaner would likely have a case. Second note, a safety issue that can cause death or serious bodily injury requires your employer to respond immediately, not within a reasonable period of time.
Thank you, Lavina, for that clear explanation. This video has already gotten a couple thousand views at my last report. I haven't got the most recent update, but I did want to play for you the ratings winner of all the videos that Lavina has done. And this is an explanation of a very common computer glitch that people were experiencing when they tried to apply. They knew they weren't qualified for regular benefits. You have to be denied those. in order to get PUA. So they wanted to apply for PUA, but then they were being sidetracked by an invitation to apply for PEUC. So I will play this video and then tell you how many views it's had.
Can you get unemployment in Washington State
Oh,
if you quit
that's
your
right.
job because your job was unsafe? Great question. Pandemic unemployment assistance is a temporary program created by the federal government to allow people who normally don't qualify for unemployment to access unemployment benefits. Generally, PUA provides benefits to people who otherwise would not qualify for up to 39 weeks. People covered under PUA include people who are self-employed, people seeking part-time employment, or people who are unemployed or partially unemployed because of the pandemic. The Employment Securities Department website has a handy eligibility checker. PEUC stands for Pandemic Emergency Unemployment Compensation. These things are terribly named, to be honest. PEUC provides up to 13 additional weeks of benefits once all other unemployment benefits have been exhausted, which is why the software glitch for e-services is so bizarre. It's giving you the option to apply for extended additional benefits before you've even applied for the base pandemic benefits. I hope that answered your question. Great question. Pandemic unemployment assistance.
Okay, I need to go back to. One second. This is what I wanted to show you. So these are, this is Lavina's collection of PSAs that she's done on unemployment benefits problems and glitches and explanations. And as you can see, she's got English versions on the left, and you can see she has an entire series of Spanish videos on desempleo in Washington. These have also been very popular. The video I just played for you on PUA and PEUC has had 350,000 views. You can also see under these, each of these videos, you'll see the number of views. A big one is on the $300 benefit that is in place right now, which is not retroactive. That's 321,000 views. So Lavina has really got a corner here on something very unusual. I don't think any other state has got this. I will be interested if anybody can report that. So thanks, Lavina. You really liven up everybody's life with these great PSAs. And that's all the news right now.
Okay, we have some, we definitely have some questions in our chat, in our Q&A room. There's one thing that I did want to add to what Lavina was saying about contacting your employer if you have a safety issue at your work site. What a lot of the judges are asking people to do, or what they're looking for, is if somebody contacts their supervisor about this and the supervisor doesn't respond, a lot of judges like to see that people have gone beyond their supervisor, that they have maybe contacted their supervisor or gone to HR or to somebody else in management. I realize that that can be a little bit intimidating depending on what your job is, but we do suggest that you really are able to demonstrate to the court that you really did try to resolve the issue with your employer before you quit. And that's also true if you are reporting some kind of illegal activity at your work site. Also with safety issues, some judges ask whether or not you have tried to contact L&I. You can always contact L&I, and if you can say, yeah, I did that and nothing happened, then that definitely will help your case.
John, I wondered if you had heard about any commissioner reviews decisions on this sort of excessive requirement. Has that been upheld, or do we know?
Well, I mean, the law as written has been followed both by the hearing judges and the commissioner's decision. There's always a question of individual circumstances and how compelling the safety issue is and credibility and other factors. So each case is treated individually, but the advice given to go high up or higher up and get it documented is sound advice, because employers, the party representing the employer at the hearing is more likely to be somebody from human resources who then can claim that they couldn't hear about the problem. And only if they knew, they would have resolved it. So that's always an uphill battle in the hearings.
And if you could document what you've done, that also will be really, really helpful, so that when you're at the hearing, it's not just a he said, she said issue. If you have documentation or a witness that can help bolster your case, that's really helpful as well. Okay, we do have some questions. Let's see. So here's a common question that comes up a lot. If a claimant is appealing a hearing decision regarding an UI benefit denial and it's due to misconduct, can the claimant still apply for PUA even though their claim is pending appeal?
So technically, no. There's no problem. Technically, there's no problem with appealing one decision and still applying for PUA. Unfortunately, a lot of the agents at ESD have been confused about this and have said that you can't do both. So it's put a lot of people into a bad situation. The issue about misconduct, that would depend partly on when it occurred in the course of the last year, and at what point the person had this job separation. So that would be a little bit hard to answer on the spot, but technically you should be able to apply for PUA.
And also one of the eligibility requirements for PUA is that you are not eligible for unemployment benefits, regular UI. So if you were denied UI, it can support your claim for PUA.
I've seen some cases of people granted and others not. And what I'm seeing is that if the job separation and the circumstances is totally unrelated to the pandemic, it's a harder case to make. But sometimes the person was let go, but the job would have been ending anyway. So that would fit into the pandemic.
Here is an overpayment question. It's a little bit specific, but we can give it a shot. If there is an overpayment and part of the overpayment is based on a PEUC claim, can the claimant request a waiver of the PEUC benefits received in 2020?
Yeah, that's a big, I'm not really sure what to make of that. It sounds like the person wants to separate PEUC from the PUA, or no, I mean from the regular benefits overpayment, which is interesting. If you're applying for a waiver, it's granted based on financial hardship, and the criterion is if you should it should be waived in equity and good conscience. So I'm not really sure how you would split that up, but that might be something to follow up with us after the webinar. Do you have any thoughts on that, John?
No, it is very complicated. These cases are very individual. So I think contacting us for individual consultation would be best.
Okay, here is another one. Can a claimant ever get an overpayment waiver after a finding of misconduct?
The requirement is that you have no fault. So if it's been, unless you've appealed and won, of course, you would, finding misconduct would be considered fault. It's really unfortunate.
And the statute RCW Title 50 specifically has a provision that says any overpayments based on a finding of misconduct are not eligible for waivers. So the only way to get rid of that would be to win on an appeal that it was not misconduct.
For the steps that we provided to prevent fraud, are those steps recommended for everyone or just for those who have actually received unemployment benefits?
No, these are basically generic ways to protect your accounts, and it's just that this is such a bad security breach, and it contains all the numbers that you need that are making it possible for criminals to access people's unemployment benefit accounts. So, but yeah, these would apply to any security breach. They're sort of standard procedures.
And here's a claimant who's really concerned about how long it is taking to get a hearing date and wants to know if, because it's taking so long, is there any chance that they would be denied a hearing date just because of the backlog?
As far as I know, they're working through the backlog. I have not heard of anybody being denied a date because it's taking so long. In fact, they're saying it's going to take much longer unless they get a huge infusion of funds. So right now it's 4 months. We're talking about 23 months. So I would not believe that they would not say, oh, you can't have a hearing because it's taken so long, but they will count on the fact that people are going to drop out of the process. That's one of the ways that they have been dealing with the backlog, unfortunately.
Here, there's another question about the links that we're providing. Is there a way to save those if someone, I know we do save, we do have our other hearings recorded that are saved on our website. Does that also save the links that are provided in the chat box?
Erin, would you be able to answer that?
Yeah, so I don't believe that the information in the chat box can be saved, though if you were to copy and paste that and put that into a document yourself, you can hold on to it that way. Lavina's TikTok has been linked in the chat box, as well as your legislative district finder. If there are other specific links that you'd like, you can put them in the Q&A box and I'll try and find those for you as well.
Thank you.
Okay. Let's see. Here is a question about how the unemployment system works. Who actually pays for unemployment?
So
there are taxes. Oh, I'll take this one to begin. So taxes are paid on wages and salaries based on each dollar or wages, and they are paid by the employers, and they go into a trust fund. In addition, there's federal money that comes into it, like during the pandemic, and extended benefits may be federal money. But in general, the taxes they're paid by the employers based on wages of the employee.
there are 3 states that have a small contribution by employees, but apparently 90% of the public actually believes that they do contribute. And I've actually seen some very strange deductions on people's paychecks in some cases. John, have you ever seen that for unemployment benefits? Now, I don't think that's really strictly legal, but we have supported having some small amount, maybe 0.1% of your wage contributed by the employee, because that would get rid of a big drawback when you're trying to get some changes done, which is the employer contention that, well, we pay for 100% of benefits. So even to have a small contribution would raise millions of dollars, 0.1% of payroll. So that's really something worth considering, although right now only about 3 other states do that.
Let's see. Here's another question about the appeals process. Is there a way to hurry up the appeals process?
Not that I know of. They do
Oh.
have an expedited process. John, you know.
Yeah. Yeah, so this is what we've heard, and this is unfortunately there's so many thousands of hearings backlog now. They will grant people what's called an expedited hearing, to put it closer, if there's a showing of some extreme financial hardship. And what we've been hearing is uh, the people who've been granted a more expedited hearing are people who can document things like utility notices, shut off notices, or eviction notices, things like that, that show uh, that they're behind, in a serious way. I've heard through others that people who just say, I need it, or I'm in bad financial condition, have not been successful getting expedited hearings. And whether you get an expedited hearing or not is not an appealable issue. It's at their discretion.
Here is a question from someone who actually has applied for a waiver for an overpayment, but is concerned about the amount of information that ESD is asking for, including a lot of personal information, bank statements, etc. This person wants to know if you have to provide all of that and if it's safe to do so.
Yeah, so waivers are based on fault and financial hardship. So if they're sending you the waiver form, they've already found that the overpayment was not your fault. But they look at, under the law, whether it's a financial hardship. In order to do that, they need information. I personally don't agree with how it's done, but that is the law now. Some people feel they'd rather just pay it back rather than give out personal information. That's a personal choice, but the information is confidential. But basically, when I've seen these waiver forms, it falls into a couple categories. They ask you about what kind of money you have in your bank accounts now in terms of liquid assets, what your income is, what your expenses are, and then you can write about special circumstances like medical issues or deaths or things like that to make the case that it would be a financial hardship. Many people, if the overpayments maybe a few $100s or a smaller amount, I know that's a lot of money if you're unemployed, but if it's a smaller amount, choose to pay it back rather than write out the personal information. But it is confidential. People who get waivers, just based on what I've seen, are people who show that their income and expenses equal, meaning there's not extra money at the end of each month to pay back, or they're in debt, or also in terms of a person's bank account. For example, if somebody had a $5,000 overpayment that was eligible for waiver, but they had $50,000 in their savings account that was just sitting there, they would have to pay it back, because they would say that the $5,000 can be paid. But if they had only 500, they would probably not have to pay it back. The only exception being is that if you could show somehow that money in that savings account, for example, was set aside for a specific purpose, and paying it back out of that would cause a great hardship. So these cases are viewed at on a case-by-case basis. And I've talked to many people over the years who would rather just pay it back rather than give personal information.
Here's a question about PUA benefits. This person was laid off and then couldn't go back to work because she had a small child at home and the daycares were closed. Would this person qualify for benefits?
Sorry, could you repeat that, Caitlin? I missed part of it.
Sure. This person was laid off from work. then apparently was called back to work, but had a small child at home and couldn't actually go back because the daycares were closed, so the person did not have caregiving. Would that person qualify for unemployment benefits?
So the person would not qualify for regular benefits because it's not considered under current law. It's not considered an excuse to turn down a job that's suitable work because of caregiving. And this is one reason why we've been working on this bill for so long. But this person probably is receiving PUA, in which case there should be, if it's pandemic related, there should be a way to use that caregiving exception to be able to continue getting benefits.
Let's see.
It depends. And I see there's some questions here too about getting the fraud protection recommendations. Did I send that to you? Do we have a link for that?
I don't actually have that link. No, I was trying to find it. If you could send that to me or share it in the chat, that would be awesome. Thank you.
Okay. I don't know. I don't have a link. We'd have to post it on Dropbox. I just have the PDF.
And then there's a question about applying for PEUC if you know how many weeks you have left on regular UI benefits, and you're concerned you won't be back to work. What do they have to do to get that extended? Is it automatic, or do they actually have to take action?
I don't know what happens on the portal, and I believe it's automatic, but I can't answer that question for sure.
John, do you know the answer to that?
No, again, we don't have access to that, and I've heard so many different things from different people. When in doubt, try to call them. If you can't get through, send them messages, and if you can't reach them, you can contact your state senator and state representatives and ask them to intervene or to find out what's going on.
Let's see. So then we have a question just for examples, just looking for an example of what a safety issue might look like that might be grounds for quitting a job. And I realize this is specific, but I think it's a good example. You're working around really, really heavy machinery. The ground is unstable. It's often muddy and slippery. There's dangerous equipment. Trip hazards, is that something that might be considered a safety issue that you would want to address with the supervisor, and then consider maybe quitting your job if it's not addressed?
See, this is where it gets very difficult of not giving like a clear 100% answer one way or the other, because working around heavy construction equipment has some inherent danger to it. On the other hand, the company may or may not be following proper safety procedures. And I have no expertise in this area. And I mean, to sort of off the top of my head, give like an answer as to, well, what type of equipment and how safe is it? That may fall into the category of something you'd want to explore with the employer, but also contact labor and industries and see if they can investigate it, because they would have that expertise. Quitting right now would get you denied benefits, no matter how unsafe. If it were just, resigning just based on this observation and without going to upper management about this. And when these cases come to hearings, the results are mixed because a judge may or not believe what an employer says about what may or may not be unsafe in a particular workplace.
You might want to also consult OSHA regulations for items that would be considered unsafe.
And then there's a question, if you worked for different companies within your benefit claim year, so you have different employers, can an earlier employer within that claim year, if they challenge your unemployment claim, is that valid? Or is it only the last employer that can challenge your unemployment claim?
Well, when you open up a claim, and again, we're talking in the current situation where you have regular unemployment and pandemic unemployment. So I will give a long answer because I think it will be helpful here. When you apply, ESD will first look at whether you're eligible for regular unemployment. And in order to do that, they will look at your employers in the base year, which is going back 4 quarters. Now, to qualify, each of those job separations would have to qualify either as a layoff, a discharge, or discharge without misconduct, or a quit with good cause. Often, if people work multiple jobs, they're often quitting one job for another job, and that would be good cause for leaving the first job. So the answer is yes, an unemployment job separation may be a problem with one of the employers or the first employer. But there's also pandemic unemployment insurance. So if let's say there was an ultimate determination by ESD, and again, the employer doesn't decide. Employment Security Department uses employer information and your information to make a decision. So if it were found that that first job separation did not qualify, then they should be looking at pandemic and whether, based on your application, whether it would fit into a pandemic claim as well.
And then here is also someone who is really concerned about the length of time it takes for an appeal process, wondering if somehow the information will get lost in the system if it's it's almost 2 years.
Mhm.
Is there any way to, again, speed it up or to make sure that that information will be preserved?
As far as ensuring that ESD doesn't make mistakes, I can't, I don't know where they go or how they manage these things internally. One thing I've just given general advice is that if you file an appeal, it gives you a number of ways you can file through your portal, e-services account, or by fax or by mail. So filing it more than one way may be a way to maybe ensure that if one somehow got lost, like if the one in the mail got lost, the fax would go through or whatever. So that's a possibility. You can also follow up. You can call the Office of Administrative Hearings and find out if it was received. Now, they are months behind. So many people who filed for appeals, it won't show up in the Office of Hearings system, but some people have, so a clerk at the Office of Hearings can say, oh, it's here, but it's not ready for scheduling yet. So if that's an issue, to put your mind at rest, that could be. Also, you can contact your state senator, your state representatives, and the governor's office, especially now that the hearing office is attempting to get a bigger budget for the coming year to hire more judges and to move these hearings ahead. But there's no secret. There's no we don't know any inside track on resolving these issues. If we did, we would certainly use them. But following up on those issues might be helpful.
Here's a question about some frustration with filling out the initial application for unemployment benefits online. People often have specific and nuanced circumstances that may be tricky to, or may not be possible, or maybe confused about how to present that information properly on the initial application. And that's been challenging for a lot of people. One thing that I have noticed on the Employment Security Department website is there is a section on there where they were giving people advice about how to answer questions, specifically for PUA stuff, but there was also unemployment benefits. So I would recommend poking around on their site. I know it can be a little bit frustrating and it's not always really obvious, but if you spend some time poking around, you might be able to get some information from the website. Of course, you could also try calling them, and it is difficult, but if you can get an adjudicator on the line, they might be able to help you with your specific circumstances.
Yes, one thing I just wanted to add about the getting somebody online. Apparently, if you call 10 minutes before the hour, you're going to have a lot better chance of getting an agent. Just looking at the statistics for call centers of all kinds, not just ESD. So don't wait until 9 o'clock, for example. That's when there'll be a lot more calls. 8 o'clock, exactly at 8 a.m. in the morning is their biggest volume. So try calling 10 minutes before the hour. That's one thing, but also please get in touch with your legislators and tell them that the phone agents have got to be increased. And one of the things that we were really hoping to get in the bill was some sort of triggers, so that when certain claim volume or certain call volume comes in, or people are on hold for hours, that would trigger a staffing increase. But they are just not geared to staff. They're much more geared to solving, problems with a computer, which we can write a book on why that doesn't always work. So please contact your legislators and ask them to pass 5193, SB 5193, to get at least a few claims processing improvements in. And one of them is that they will have to put on their data dashboard running statistics about the claim volume, about the call volume, the wait times, the number of all circuits busy messages that go out, the number of abandoned calls. So if we have a steady stream of those numbers being reported every month, that will at least give us a little bit of leverage, some sunshine to get some action when there's, when it's clear that they need more staff. We just have to pressure them to add staff.
Let's see. Here's a person with a pretty common situation, unfortunately. Opened a PUA claim and last summer was receiving money until November, and then something happened and the claim has been stuck in pending ever since. They want to know if they should contact their state representatives, the state senators, just one of them, if they should contact all of them. This person has said they have been sending ESD messages on the website, emails, but has not received any response.
In contacting your state senator and representatives, I've recommended calling and or emailing all three of them, because they have different staffs and people are busier, and it's hard to tell which one might have a staff member that's going to have more time or be more engaged with this issue. So by contacting all three, as well as the governor's office, there's no harm to that. And whoever gets back to you first, work with them. I think we've heard just from we've gotten thousands of calls about these issues, and it shows that in spite of the department's claim last summer that they resolved initial claims, that's simply not true, just because of the number of issues since then, the number of claims since then, the number of overpayments and other cases that are in in pending status. So it's important to do that advocacy. It really doesn't take much time at all. And I've heard mixed results, but that means that there's a good chance or a fair chance that these contacts will lead to at least some progress on your case.
Okay, I think we have time for just one more question. Again, this is a pretty common one. If you have been notified that you have a very, very large overpayment and you have requested an appeal, what do you do if you're still getting notices from ESD about your overpayment? How can you handle that?
Yes, so we've been told by the governor's office and ESD that there's a stay on these overpayment collections while people are in such a crisis going on. That doesn't seem to be happening. People are still getting these notices. But in the case of where you have filed an appeal specifically, you should be able to call or email Benefit Payments Control and ask them to put a stay on your overpayment collections while the appeal is pending. And as you can see, that could be months, many months. But that is something they are supposed to provide. And if you can write them at BPC unit, Benefit Payments Control Unit, at esd.wa.gov.
And also, I've heard from a few people who called and got through and talked to a person, and with mixed results. So one person I talked to told me they were talking to someone who was a bit hostile. They called back at another time and they got someone who was more friendly. So I just want to share that with you.
Yeah, sadly, one of the best recourses for people is to find somebody on the phone, as much effort as that's going to take. But this is the way the system is unfortunately working. That's one of the few things that actually seems to work in many cases. Also, contacting your legislator. That has helped.
And the phone number for Benefit Payment Control is on the website as well, and it was just posted in our chat. Thank you.
Okay, it's 12:57. We've got exactly 3 minutes left. Do we have time for one quick question?
Yeah.
Okay, all right. Okay. Is standby still a status? Can you still request that? So the person has gotten back to work, but they're not working at the same rate anymore as before the pandemic, wants to know what they should do and if there's such a thing as requesting standby.
So the concept of standby has been around for many, many, many years, long before the pandemic, and it simply was a way for an employer to work with ESD to tell them that your unemployment is very temporary. It might be 4 weeks, 5 weeks, 6 weeks, something like that, so that you wouldn't have to search for work. Then the pandemic comes along and the governor suspends the job search requirement. So then what's the point of being on standby? And everybody in some sense was on standby. But you should be aware that being put on standby is something that your employer has to do with ESD. It's not that something you request to ESD. And since the job search requirement has been suspended anyway, there's really no point to it. It doesn't it doesn't change the amount of your benefit or your job search requirement. So, this was very confusing in the spring because some people were told by the employer, go file for unemployment and come back when you can, or come back when we're up and running again. And so people would tell ESD they were on standby, and ESD would say, no, you're not, because there wasn't that communication with the employer. ESD created a lot of confusion, but being on standby is not a requirement to get unemployment benefits if there is a lack of work or a temporary layoff.
One point about the chat here, I see there's some requests for the PowerPoint. Erin, would you be able to send those to, send the PowerPoint to people who have requested it?
Yeah, I can go through and find the emails for the people that requested it. Once I have the PowerPoint, I will be able to email them directly for it.
Oh, okay. Yeah, I don't think I sent it to you. I will send it to you.
Cool.
Thank you.
If anyone else wants the PowerPoint, just go ahead and shoot a comment in there. I will go and find your emails afterwards, and then I will email you directly.
Thanks, Erin.
Okay, thank you very much, everybody. It's just exactly 1 o'clock. We will be having another webinar next Monday. And if we didn't get to your questions, feel free to call our office or come back to the webinar next week. Thanks. Bye.